Good day, ladies and gentlemen. Thank you very much once again for following our series on company issues. This time, we are going to speak about resignation and the removal of a director from a company. I am Sukhdev Kaur from Law Chambers of Sukhdev. I am an advocate and solicitor of the High Court of Malaysia at Kuala Lumpur. And together with me is Seelan.
Good afternoon, everyone. I'm Shivajini Seelan from JS Partners. I'm an accountant and we focus on corporate affairs and corporate matters.
Together, we will be discussing some of the issues and procedures in respect of resignation and removal of a director from a company. Ladies and gentlemen, before we begin, we'd just like to advise you that the issues and matters that are discussed in this video are information for the public, and it is not to be construed as legal advice. Any legal advice that you may seek or you may want, you can always get in touch with me or Jeannie, and we'll be happy to assist you accordingly. Okay, so Jeannie, today we have a very interesting topic to discuss. Shall we start with the resignation of a director from a company secretary's perspective? Can you please explain about the resignation process? I just have to add one question prior to that. Can you explain the difference between a designated director and a statutory director?
Okay, sure. A designated director would be a director who is given the role as a director in a company, but he or she may not be in the board of directors or in the statutory books as a director. So it's just a title given for the job that they may use the term director. So a statutory will of course be a director who is in the books of the SSM records, and he basically would be responsible with the acts of filing the documents and accounts in, and he has all his statutory rights.
Okay, can you explain the resignation process for the designated director and the statutory director?
Okay, for a designated director would be, of course, following the Employment Act, he would just have to pass a notice of resignation to his employer. When it comes to a statutory director, in order to pass, it's under Section 208 of the Companies Act, and he would have to give a written notice of his resignation to the company secretary that he would want to resign, and a copy, of course, to the board of directors.
Okay.
And with that, the secretary will be able to move forward with the instruction and prepare the necessary documents.
I see. Okay, so Section 208 of the Companies Act 2016, it says vacation of office of director. One of the circumstances is resignation by giving a written notice to the company at its registered office, which is basically the company secretaries, right?
Yes, that's right.
Okay. Now, moving on, we'd like to discuss about the removal of a director. But can you explain what is the difference between resignation of a director and removal of a director?
Okay, a resignation is basically his consent and he's willing to resign according to his own will. And he basically, sends a written notice quite easily to, the necessary secretary and the board of directors. However, a removal is when he refuses to resign. And he doesn't want to resign as a director, and he has now moved toward a removal of director because the rest of the board of directors want him out.
I see. Okay. So this, when you said board of directors, right? So this would be more than one person as a statutory director. Then it becomes practical to call for a meeting. So that the other director can be removed. But now that we can actually incorporate a company with just one director, right? What happens if that single director, and he's also a single shareholder of the company, passes away?
Okay, so in the event a director passes away or becomes an unsound mind, the company secretary would be able to call for a meeting of the next of kin or the other representatives to appoint a new director. Okay, of course, the next of kin would be, of course, someone that who have the probate, and there is proof, there is such a thing that this person is the next of kin. Only then that this procedure can happen as well. But in the event, this is not able, or there's no such documents to state that this is the next of kin, then the SSM has the right to strike off the company within 6 months from the passing.
Okay, so this is provided by Section 209 of the Companies Act.
That's right.
Yeah, where it talks about the resignation, vacation, or death of a sole director or last remaining director, right? Okay, now, like you have explained, that it's not only in a situation where the sole director has passed away upon his death, but it's also by reason of his mental incapacity. Then,
yes,
and in accordance to the Mental Health Act 2001, so that his estate may manage his appoint a person as a director. Sorry. Okay, and so in this circumstance where there's just a single director or last remaining director, the process of the procedures of removal of directors that is discussed at Section 206 becomes impracticable, isn't it?
That's right, exactly. That's right. Because he may be the director, the sole director, and he is also the sole shareholder. So, he won't be able to remove himself. So it won't be, practical in this sense.
Well, I suppose the alternative to that is for him to voluntarily wind up his company.
Yeah, so I mean, if he really doesn't want his company, then the option is, of course, to wind up the company, and he can basically strike it off.
Okay, all right. So let's come back to the procedures of removal of directors, which is provided by Section 206 of the Companies Act 2016.
Yes. Okay. So in order to remove a director, basically a director will be removed by an ordinary resolution. Okay, and it would need to be passed by a physical general meeting. Okay, and a notice would have to be given for, a period of 28 days. Yeah, and to the particular director, and to his last known address.
Okay, let's go through that again. Section 206 here is applicable to both the private company and the public company. So when you spoke about the special notice with 28 days to be given, is this applicable to both the private company and the public company, or either one?
With this new act, it is applicable to both the private and the public.
Okay, and to his last, to be served at his last known registered address, right?
That's right.
So what happens if, how do you prove that it was served at his last known registered address?
Okay, well, the procedure is basically, we would serve the notice at the address that has been registered with us, and this could be, by registered post or by our dispatch, who can actually give us an acknowledgement. And registered post, of course, if the post is failed, then we would get a notice to say that this is, this person is not there. However, the law states that it has to be in the last known address. Now, it's his responsibility as a director or shareholder to inform the company secretary of the changes of his residential address. And sometimes, and most times actually, they do not inform on the last the updated address, and so therefore he may not get the notice, and this might not work to his favor. At the same time, this also applies to LHDN as well. If you don't inform on the latest notices, the latest address, they would just send you notices to your last known address. You'll be getting different colored letters, and you would not even know such things is happening actually. And sometimes this is what happens until they go to the airport and realize they are banned from traveling.
That's a bit too late, isn't it? But then again, you see, matters with LHDN, okay, let's put that aside, because you see, for someone who is a statutory director of a company, he's probably not expecting, to be removed during his tenure there, isn't it? So,
well, he probably didn't expect to be removed, but usually for a removal to happen, usually it would start with, asking the director first to resign, voluntary resign. And, it has come to a stage where he refuses to voluntarily resign, and now it's moving towards removal. So for the removal to happen, it will not be a shock. He obviously knows it's moving towards that. And he eventually will become removed. So he's aware of such a situation. It's just that, that's the thing. The addresses always have to be updated for whatever reason.
Okay, so whilst the authorities is able to stop the director from leaving the country, because there is the issue with LHDN, the same thing doesn't apply in the sense of the removal of the director, because no notification is given to the immigration department to stop such a director from leaving.
Yes, that's right. Yeah.
Okay, right. So, ladies and gentlemen, regarding the requirements for the 28 days notice is provided under Section 322 sub 1 of the Companies Act 2016. Okay, and the Companies Act 2016 now has made very clear the issues that used to arise as a result of the manner the provisions were stated in the Companies Act 1965 as to whether ordinary resolution and the number of days applicable for the special notice to be given to a private company differs from a public company differs from a private company. Okay, so it's now clearly stated. All right, now moving on, after the notice has been given, okay, and the director has come to know about the resolution for the removal to be held, okay, what is the next course of action available for this director?
Okay, so once he received the notice, he'll be able to basically do an oral representation or a written representation regarding the resolution that has been passed with reference to his removal. And he can also say that he wants it read at the special meeting. So this is something he can do when he receives the notice.
Okay, I'd just like to rewind a step. When we were talking about the service of the special notice, okay, what if the special notice, because under Section 322 sub 4, it says that if it is not practicable to give such notice of 28 days, then you just have to give a notice for 14 days. So what sort of circumstances would it be not practicable to give that 28 days notice?
Okay, so the reason why sometimes it might not be practical is because most of the time it's always in a hurry. Now the reason being is the director might have taken money out of the company. It might have been a fraud. He might be issuing unnecessary checks, or it could be many of these kind of reasons that will cause the situation to that it can't we can't wait for him to basically wait for the 28 days, or he refuses to sign the audited accounts, and we basically need him out fast in order for this to happen, things like that, which is the reason why 28 days might seem very long.
I see. So I suppose if there was, if the director is under, some mental health issues as well, isn't
Yes,
it?
that's it.
Yeah. Okay.
Yeah.
All right. So coming back to the director giving oral and written representations for, reasons to be heard that he is not to be removed from the company. Okay.
Yeah.
Yeah. Very interestingly, the situation of a removal of a director in most circumstances would be family related businesses, isn't it?
Yes.
Okay,
Yes.
what happens if there's a deadlock?
Okay. So yeah. So some situations there might be a deadlock because there might be only two directors, and the same two might be shareholders as well. So there's a deadlock, and in those situations, sometimes it either they settle it amicably by just discussing what needs to be done, or what he wants in order to be removed, or it might even carry on to being sued and going to courts and things like that. So usually removal is a very messy and complicated process because it's a lot of emotions going through it. And we of course don't want to, the process is very tedious because both parties will be talking to us and telling us it's like a divorce matter.
Okay, yeah. So, how are the votes casted? I mean, to draw.
Votes are basically casted at the meeting. The votes will be either casted based on number of votes or the number of shares
Of each shareholder.
Yeah.
Okay. So, does it go by?
Majority,
Yeah. So does it go by a simple majority? Is that the term used?
yes, that's right. So I mean, it needs to have at least 75% of, yeah, that's right, to be considered approved. Yeah.
I see. Okay. So, and if he's not happy with that decision, then obviously he's going to, there is no appeal procedure, but to actually file a suit in court to,
Yes.
To seek for a prayer that the company reinstates him as a director. Okay.
Yes.
Now, that will be a discussion for another day because generally the courts are not going to rule the company against the decision that's been made because the courts do not interfere unless the director has a ground of grounds based on the procedures that was not properly carried out or the number of days that's not properly calculated or he wasn't heard or wasn't given an opportunity to be heard. That's a different thing. Okay.
Yeah.
Now, what is a garden?
Sorry, the majority must be 51%. Yeah, 51%.
Okay.
Yeah, to be.
All right. Okay. So, what is a garden leave?
Okay. Sorry. Okay. A garden leave would be. Sorry. So the garden leave would be someone who has basically given a leave to stay away from the operations or the office, but he will be still remunerated. And the reason why this is given sometimes is to avoid anyone from, the person has been messing up the books or has been causing some, maybe ill feelings between the relationships that are happening in the business, and it might be better for him to take a break. This is why garden leave sometimes is given.
Okay, so basically just to stay out and
stay out and yeah, that's right.
Not to get involved with the running of the company. Okay, that makes sense. But now, whether there is a decision taken or whether there's a deadlock at the meeting and pending amicable settlement, or even if there is a resignation. Okay, well, I suppose because of resignation, then whatever is due will be paid. So that's the damages that. So coming to the deadlock situation, Okay, removal of the director, whether it's by, whether it's passed at the meeting or whether there's a deadlock. Let's come to damages.
Mhm.
How will the director who's removed be paid damages? Is he entitled for damages? Is he entitled for remuneration pending the amicable settlement? When will the removal take effect in order for remuneration to be calculated or damages to be calculated?
Okay, so it will all depend on the situation, but usually by the time it reaches removal, it's always very bitter, the relationship. But just say the meeting goes on and he is, been approved to be passed the resolution of the removal, then immediately, within 30 days, the submission of the relevant forms, which is the section 58, which is the form to submit to SSM on the removal of director. And if he has shares, section 105 would be the form to be used. Previously it was 32A, now it's 105 to be filed. Now, and then at that point, they can also calculate, if there was any amounts owing that needs to be paid to this particular director. At that point, of course, it's a discussion. If there was a contract of employment, then it'd be, of course, easier because you can just follow, what is due up to the date. But if there was no contract, then of course it can get messy, because there's nothing really written to say what is owing.
I see. Well, then I suppose the company will just have to go through the books to see what was normally paid at what intervals.
Yes, if he had forked out his money in advance, then they have to, actually check and see what is going to him. Yeah.
And if the director was involved in more serious charges, like, for example, CBT and things like that, then the question of damages as a result of the removal of the director from the company should not arise, isn't it?
That's right. Yeah, that's right.
Okay, so we have come to the end of our discussion on the resignation and removal of directors. We have discussed, the differences between the two procedures. We've discussed about the procedure for the removal as well, and the provisions that are provided in the Companies Act 2016. Okay, it's not like what Jeannie Seelan has said. It's usually messy. Because this is a family-oriented business most of the time, and things becomes bitter, so it becomes a tedious process. All right.
That's right.
For our conclusion for today's discussion, Jeannie, would you like to say something?
Well, in summary, we would always encourage the person, or speak to both the directors, or more than two, in fact, sometimes. To resign, and to hopefully they can amicably resolve the situation before it moves towards a removal procedure, because it just becomes very, very complicated and messy. So yeah, we always hope for that.
Okay, and until a firm decision is taken, you're not going to be able to do your part to update SSM on the changes in the list of directors, shareholders, and stuff, isn't it?
Yes, that's right. Okay. Yeah.
Okay. Well, it's not all that easy as well to attend to the matter in court, whether it is for acting for the company or acting for the director who is removed, because there'll be a lot of issues that obviously need to be attended to, and whether as a result of those issues, the court is able to set aside the decision for the removal that was taken by the company. I mean, if it's procedural or not, then probably that is one point for the director removed. But if it's the overall decision, then that's going to be a difficult call for the courts. Okay. Right. So with that, we end our session today, and we hope to bring you more discussions in our next series. There's no slides for this time round because of the issues, that's involved. And we hope that you find our video, the information that we have given very useful. Do contact us if you need specific advice, and we'll be pleased to help you. So signing off, take care, stay safe, and stay at home.
Yes. Okay. Yeah. Take care. I hope the information has been very useful as well. And do contact us if you require any information or guidance. And stay safe and take care.
Bye, Jeannie.
All right. Bye, Sukhdev. Bye.